Hey there, estate planning attorney Paul Rabalais, and in this video we're going to talk about 8 different mistakes that people make with their power of attorney. Okay, so on these videos on YouTube, it seems like power of attorney seems to be a really popular topic, and I'm going to assume it's because people are living longer. As a result of that, more people during their lifetime, they're becoming incapacitated, so we see these power of attorney issues come up all of the time. So you might think, power of attorney, it's pretty simple. You just sign one and you're done with it. Well, it's not quite that simple. Like anything else in estate planning, anytime you involve money and property and investments and relationships and people sharing an inheritance when someone passes away, it can be real sticky, along with all of the regulations and rules that different financial institutions and title companies have. So powers of attorney really can be a complicated topic. So I'm going to go over 8 mistakes that people make. Perhaps you can arrange things so that you don't make any of these mistakes. Mistake number 1, kind of obvious, kind of simple. It's the failing to have one. So going back to the basics, if you don't have a power of attorney and at some point during the rest of your lifetime, you get to a point where you can't transact any of your business. You can't sign your name. You can't take a necessary withdrawal from your IRA that is solely in your name. You can't sell your home that is in your name or is in the name of you and your spouse, and both signatures are required to sell it. You can't transact a vehicle, sell or trade it in that's titled in your name. Or maybe you're not going to be able to transact various brokerage accounts or bank accounts at different financial institutions. And so your family is stuck if you don't have a power of attorney. They're stuck having to go through really what is difficult, a very court and attorney involved guardianship, or as we call it here in Louisiana, interdiction proceeding. Very complicated, very expensive, takes a very long time, requires court hearings, where judges have to get involved in your estate by declaring you incompetent and appointing someone to be your legal guardian while you're alive but incapacitated. So the fact that you will have a power of attorney really increases the chances that court-involved guardianship or interdiction proceeding is not necessary. So that's number 1, failing to have one. Number 2 is appointing the wrong person. So many times I've sat in my office and, dad or mom will say, yeah, we've got to designate, we really need to have one of those powers of attorney, but, we appointed our son because he's so responsible to be the executor of our will. So maybe on our power of attorney, we'll appoint our daughter because we don't want to hurt her feelings by not giving her a role. That is the wrong reason to designate someone as having power of attorney for you. By naming someone on your power of attorney, you're basically saying, you know what, when I'm cuckoo, here's all my money, you manage it for the rest of my lifetime, in spite of what your siblings, your aunts and uncles, your nieces and nephews, despite what all of they say and all the pressure they put on you, you handle that responsibility. So sometimes the power of attorney appointment, because that role may have to be filled for many, many years, it's a more important role than the who's going to handle things when you die role. So the power of attorney appointment, very, very important. Naming someone because you don't want to hurt their feelings is the wrong reason to designate someone. Designating someone because they're the right person for the job, now that's the right way to do it. So mistake number 3, not being specific enough in the power of attorney. Seen a lot of one-pager power of attorney over the years that says, I, John Doe, appoint Mary Doe to be able to do anything I could have done during my lifetime. Not good enough. This could be a state law issue, but here in my state of Louisiana, state law always has certain transactions that for your agent that you name in your power of attorney to have the power to do certain things, that power must be expressly provided for in the power of attorney legal instrument. Things like the power to handle your real estate transactions, the power if you want the agent to have the ability to make donations either outright or in a trust on your behalf, the power to handle a probate that you're involved in, perhaps as an heir, the ability to contract a loan, compromise a matter, and the all-important, the power to make healthcare decisions on your behalf. In fact, that one's so important now that most people sign 2 different powers of attorney, one for financial and real estate and business type matters, and then another one for healthcare, medical decisions, access to medical records type deal. So it can be all combined into one. Many people, create 2 different powers of attorney because sometimes they want to appoint different people for each matter. Mistake number 4 is failing to name a backup or alternate agent in your power of attorney. Too many times I've seen wives, for example, they get the power of attorney done, they appoint their husband as their agent, and then 10 years later, that wife becomes incapacitated, her husband's already dead, and now it's as if she doesn't have a power of attorney. And maybe when she signs her power of attorney, she says, well, I'll just update it if my husband happens to die before me. But when her husband dies, maybe she's not in a condition where she has the capacity to update her power of attorney. So it's always important to name a backup agent or alternate agent on your power of attorney, particularly if the first person that you named is your spouse or someone in that same generation as you, who it's a distinct possibility that they may predecease you, or when you become incapacitated, they're also unable to transact business on your behalf. So naming a backup is mistake number 4. Mistake number 5, I would say in general it's a mistake requiring that 2 or more people act jointly on your power of attorney. So unlike the executor that you name in your will, or perhaps even the trustee that you name in your trust, under those scenarios of making that appointment of who's going to handle things when you die, that could be 2 or more people working together, because typically there's no gotta move real fast, need both signatures right now. And so it's common for people to designate 2 or more people to handle their stuff when they die. But under a power of attorney, sometimes decisions need to be made quickly, particularly in the healthcare area, but also in the financial situation as well. So it's easier to get things done when you name one. And maybe the bigger reason to not name 2 or more people acting together is that many financial institutions, I've experienced this when on behalf of our clients, we've submitted powers of attorney where they named 2 or more people and required them to act jointly. The financial institution has told us, I'm sorry, Mr. Rabalais, we just don't accept a power of attorney when we have to work with 2 or more people together. So oftentimes many folks are satisfied when we say, well, if you want to name 2 or more people, how about if we say that they can act jointly or separately? So either one can act on perhaps that parent's behalf. So be aware of naming 2 people jointly being required to act on your behalf using a power of attorney. Mistake number 6. Again, perhaps a state issue, but failing to appoint a guardian or curator. So in the event a guardianship, or as we call it, an interdiction in Louisiana, is necessary, you have the right under our Louisiana law to designate who you'd want the judge to appoint as your legal guardian if that guardianship/interdiction is necessary. That designation doesn't have to be in a power of attorney, but it often is. So guess what? You get to suggest, hey, if a judge declares me legally incompetent and I'm not able to transact for myself and the judge has to appoint somebody to be my legal guardian, I want this person to be my legal guardian. If it's not this person, I want it to be this person. And a judge has to, is bound by that designation. So that's the first order of priority in one of these guardianship proceedings. Mistake number 7, not inquiring to your financial institution. Let me give an example. Let's say, Mark Moneybags is 70 years old and he's getting his power of attorney done. He has all of his financial accounts, his traditional IRA, his Roth IRA, his brokerage account, other money market accounts he may have. They're all at one financial institution, and let's say it's a very large, brokerage firm, and that could be Schwab or Fidelity or Merrill Lynch or any of the big ones. And he gets his power of attorney done in his lawyer's office, and he presents it to his son. Son, here's my power of attorney. If you need it, you can present it to my large financial institution, and you shouldn't have any problem transacting business on my behalf. But what really maybe Mark Moneybags should do is contact his large financial institution, brokerage firm, call it what you will, and say, you know what, I've signed a power of attorney that my lawyer prepared for me. I want to make sure that, that if he needs to use it, he's not going to have any problem with you large financial institution. And the large financial institution may say, you know what, Mark Moneybags, you're one of our valued clients. We would prefer that you sign one of our institution's power of attorney forms. So inquire into that while you're getting all of your legal affairs prepared. You may think it doesn't make sense because you had your lawyer prepare a power of attorney. Some stuff in estate planning doesn't make sense. The large financial institutions, they have their policies, they have their regulations. Sometimes you just got to live with them. So inquire to your financial institutions whether they'd accept the power of attorney that you've signed, or whether it's going to be easier for the person that you've designated to handle things on your behalf if you've signed the financial institution's special power of attorney that they have prepared. And then mistake number 8 is, and most people know this, but mistake number 8 is assuming that your power of attorney extends beyond your death. I've had many people tell me, Paul, I named my son to have power of attorney, so when I die, after I die, my son, because of that, is going to be able to access my accounts, sell my house because I gave him power of attorney. Well, ding dong, you're wrong. When you sign a power of attorney, the effectiveness or validity of it terminates upon your death. There's not one state in our great country where someone's power of attorney extends beyond their death. Once they die, then if they have things in their name, the executor of the will has to put wheels in motion to get the authority to transact stuff after death. Or if you have some type of assets in your revocable living trust that becomes irrevocable upon your death, you perhaps named a successor trustee to be able to handle those assets after your death. But the power of attorney, their job is over when you die. They're not going to be able to transact anything after your death. Okay, so all that goes into the making sure you don't make mistakes with your power of attorney. Another mistake you might make is failing to hit the like button, but an even bigger mistake is failing to hit the red subscribe button if you haven't already done it, and the notification bell. That way you don't miss anything as I keep creating day after day these estate planning educational videos. Okay, we'll see you next time. Have a great day.